My name is Alia Izani and I will explain about intellectual property. Intellectual property refers to the ownership and right to creative works of an individual or a company, which is the idea that certain products of human intellect should be protected. IP legally protected a firm or individual intangible asset, which is non-physical asset, from unauthorized use or implementation without consent. IP include inventions, literary and artistic works, designs, symbols, names, and images utilized in commerce and businesses. The owner of intellectual property has exclusive right to their creations. There are three types of intellectual property that will be explained in this video. They are copyrights, patents, and trademarks.
Hi, my name is Namashita. Today I would like to present that the organization handle intellectual property in New Zealand. Okay, the organization is called as IPONZ, which is the Intellectual Property Office of New Zealand. Okay, this organization is the governmental body in New Zealand in charge of patent, trademarks, design, claim variety rights, as well as their currency and registrations. And it is a division of Ministry of Business, Innovations and Employment of New Zealand. And this organization is aimed to enable people exploit the full economic potential of their intellectual property according to its website.
Hi, I'm Melissa. I will present about copyright. Copyright is a kind of intellectual property that preserves right of author as soon as the work has been specifically identified form of the expression by the creator. Copyright law recognizes a wide variety of work, some of which are painting, drawing, musical work, audio recording, computer program, novels, blog, and movies. When a work is generated independently by a human author and has a high degree of originality, it is referred to be an original work. The term of independent creation refers to the act that constructing anything without making use of models or blueprints. The Copyright Act 1994 in New Zealand give owner of copyright the ability to prevent others from engaging in the certain activity using their works, including duplicate and promote their product. The Copyright Act of 1994 of New Zealand and any modification that have been made to it since then provide a legal basis for the copyright protection in New Zealand. The Business Law Policy Unit of Ministry of Business, Innovation and Employment is the body responsible for its administrations. New Zealand is a member of country of International Copyright Convention, including the Burns Conventions of 1928 and Intellectual Property Rights 1994. We will now go on the owner right against the copyright law. The first advantage is that the owner have unlimited authorization to keep any profit made via the use of economic rights. Not only that, the owner of the copyright work also have the authority to assign, license, or transfer the economic rights associated with the work. Besides that, the length of the time the work that protected by copyright law is depending on the kind of work. The literary work, dramatic work, artistic, and the musical work all have a life expectancy of 50 years after the author has passed away, as is shown by the timetable. Next, the duration of copyright protection for recording, motion picture, and communication work is 50 years from the time when they are made accessible to the general public, and 25 years from the date of the first publication of a publication, including typography. That's all from me. Thank you.
My presentation is about patents in New Zealand. First of all, what is patent? A patent is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. A patent is a legally enforceable right that is granted for an invention. In New Zealand, patentable invention could be a new product or process, new uses of known products, business methods, computer software, or genetically modified organisms. To obtain patent protection, invention or innovation must, as a minimum, be novel, involve an inventive step, and be useful. This means that invention must not already be in use or published about. Therefore, it is important to keep invention confidential if wished to obtain patent protection. New Zealand patents protect within New Zealand. Once an application for a patent is requested for examination and a patent is granted, a patent description is published in exchange for exclusive rights to be published to encourage innovation. As patent holders, they have the exclusive right to commercially use the invention for up to 20 years. During this period, legal action can be taken to raise funds for the business, grant or sell patents, and exclude the use of patented inventions by others. Legal action may be taken against a person who infringes on a patent granted in New Zealand.
Next part is, what is trademark? A trademark is any symbol that may be expressed graphically that distinguishes the goods or services of one company from those of other companies. There are three types of trademarks. The first type is known as sign. Signs include a brand, color, device, heading, label, letter, name, or any other combination thereof. Another type of trademark is collective mark. A collective mark is anything that helps customers identify between the goods or services provided by members of the association that owns the mark and those offered by other businesses. Lastly, certification mark. A certification mark is a symbol that declares the goods or services it is to be used with have been approved by the mark's owner in terms of its origin, material, method of production, quality, accuracy, or other attributes. The slide shown is the main functions of trademark. First and foremost, trademark identifies origin. A trademark makes it easier to determine who is responsible for a product or service and who is related with that source. Besides, it provides choices for customers. A trademark makes it easier for customers to choose products and services. Trademark also guarantee the quality. Customers identify a particular brand by its well-known quality. Lastly, for economic aspect, a well-known trademark can be an asset. This is because it is possible to license or franchise trademarks. Next part is the importance of trademark registration. First and foremost, trademark give the owner exclusive rights. In New Zealand, owners of registered trademarks have the only right to use their marks in commerce. They also have the legal right to sue people who use their trademarks without their permission under the Trademark Act 2002 for infringement. The Trademarks Act 2002 additionally lists criminal offences for using a registered trademark for commercial advantage without authorization. If found guilty, the offender faces a maximum 5-year prison sentence or a fine. Apart from that, trademark can also provide legal protection. By registering a trademark, companies can prevent other individuals from copying their brand. The Trademarks Act 2002 offers companies a chance to register their legal trademarks and protect them from unauthorized copying, sometimes known as counterfeiting and other forms of brand piracy. For the last part of my presentation about trademarks, Trademarks Act 2002 shall be referred to when referring to trademark laws and regulations in New Zealand. If a trademark is registered under this Act, it is valid for 10 years starting from the considered date of registration unless it is cancelled before that point. Additionally, it may be renewed every 10 years. Thank you.
Okay, the first step is to find the applications accompanied by provisional specifications for the design pattern of Nike Air Max 90. So the step is provisional specifications should describe the interventions in sufficient detail so that a person skilled in the relevant field can put the interventions into effect without any undue experimental. Okay, the next step is to find the complete specifications at IPONZ, which is Intellectual Property Office of New Zealand. within 12 months of filing dates or provisional specifications, it is to examiner will consider the applications and issue in examinations report within 4 until 8 weeks. So the approach will result in an yearly acceptance and publication dates. Next step is the examination and acceptance of New Zealand patent applications. Okay, in this step, complete specifications is examined by the Intellectual Property Office of New Zealand. Once any objection raised by examiner are overcome, the application will proceed to acceptance. Okay, when the examiner accepts the applications, the acceptance is advertised in a patent office journal. Okay, the last step is grants of New Zealand's patents and renewal fee. Okay, and this part is renewal fee are payable for 4, 7, 10, and 13 years from filing dates of the complete specifications, and the maximum patent term is 20 years.
One of the products of copyright is music. And who is eligible to register? Individuals or businesses in New Zealand do not need to register for copyright such as trademarks or patents, because there is no official system for copyright registration in New Zealand. When something is published, copyright is automatically applied under the Act. There are 4 general conditions that must be completed for a work to qualify for copyright protection. There are a few things you can do to protect your rights. Firstly, include the copyright indicator symbol on your work. Then, the name of the copyright owner and the year of the copyright work was first created. By labeling can show who owns the work and when it was created to determine how long it is protected for. Even when the symbol is not displayed, everything published is protected by copyright. The second step is to keep a record of more detailed information, which can include the owners or their legal representatives' contact information, licensing terms and conditions, as well as acknowledgement to those who contributed to the works and more. Thirdly, to further protect yourself, an individual can appoint a licensing agency to represent them. There are organizations that are authorized to grant copyright licenses for specific purposes and collect license fees or royalties on behalf of copyright owners. For instance, the Single One Music license includes both copyright in the music, which is owned by the songwriters, and copyright in the recording, which is owned by the record company or artist. According to the official website of New Zealand's Ministry of Justice, it costs $200 to apply to the Copyright Tribunal to pursue a file sharing infringement.